In today's video, we provide general guidance to medical doctors and medical spas about handling laws and regulations governing regenerative medicine and stem cell practice. Hi, I'm Michael H. Cohen, founding attorney of the Cohen Healthcare Law Group. We've advised over 1,000 plus healthcare industry clients on healthcare and FDA legal issues. Our clients include medical spas and healthcare companies that work with stem cell therapies, regenerative medicine, and the latest therapeutics. In our prior video, we gave these 3 tips for medical spas and physicians doing regenerative medicine therapies in an aesthetic practice. First of all, don't look for a yes/no answer. Rather, look for a risk assessment from your healthcare lawyer, which can help you make a solid business judgment as to where you want to take measured risks. Second, some of the most important questions have to do with state licensure, which spells out exactly who can do what when it comes to cosmetic treatments in situations where the practitioner is not a licensed medical doctor. Third, don't take others' advice and examples as true statements of what the law actually says. Today, we'd like to add on to those 3 tips number 4 and 5. Tip number 4, whenever the manufacturer tells you what is legal or lawful to say or not to say, that's probably, in our experience, bad or wrong advice. Ignore it, but most important, get your own legal counsel. Recently, one of our medical spa clients was using some centrifuge or other machine that supposedly would do something with stem cells that made them easier to inject better, stronger, faster stem cells. Remember that movie, The $6 Million Man? Technology made him better, stronger, faster. That was the promise of these stem cells. And in this case, the manufacturer was full of marketing language that talked about compliance, FDA compliance, HIPAA compliance, and compliance everywhere. None of it, of course, was true when you looked into what they were actually saying. While FDA does not regulate the practice of medicine as a service, FDA does regulate stem cell products under the HCT/P protocol. That stands for human cells, tissues, and cellular and tissue-based products. The manufacturer in this case completely ignored these rules and made up its own marketing claims and even made up its own FDA rules, so it thought. So tip number 4, some are honest, but in general you can't rely on what the stem cell or any other manufacturer or distributor tells you. Do your own independent legal research. Tip number 5, make sure your healthcare or FDA lawyer understands the many interlocking layers of law. We've already mentioned that medical doctors and other healthcare practitioners are normally licensed by the state, and that state allows them by the license to do certain things and prohibits them from doing certain other things. Even medical doctors who are supposed to have an unlimited license to diagnose and treat disease under the law are limited by standard of care. That is, they can only practice in a way that meets what the medical board by professional consensus considers the standard of care. And doctors have to abide by federal laws such as those, for example, governing the manufacture and distribution of stem cell products, and also that whole suite of laws governing advertising and marketing for all of their therapeutics, including stem cell products and regenerative medicine. Now, HIPAA, it's its own little separate statute with legal obligations that are distinct from FDA rules and licensing laws. And then there's informed consent, a whole nother world. It just goes on and on like this. All these layers of law intersect and interlock, which is why we often refer to healthcare law as a Rubik's Cube of regulation and obligation. You have to follow all the threads, all the blocks, and make sure that you understand how they work synergistically. It's kind of like understanding herbal medicine or any system of healing. There isn't just one active ingredient like you have in a drug, even in a drug. But in plant medicine, while we can understand the impact of various phytochemicals in a scientific sense, we also know that all the ingredients work together in ways we don't fully understand to produce certain outcomes. Of course, as you know, I'm all for scientific method, and I'm all for breaking things down and breaking down systems into their component parts as one methodology for discovering the truth. And also as a legal scholar and an attorney who's written 6 or more books on healthcare law governing complementary, integrative, traditional medicine, I also appreciate how whole systems are more than the sum of their parts. That's the premise of holism. And I approach the law the same way. We work, like you, on a systems level, as well as rigorously analyzing the individual components. Thanks so much for watching. If you still have questions about this video, and no doubt you do, click on the link below, cohenhealthcarelaw.com/contact, to send us a message or book an appointment. Let's talk about stem cells and regenerative medicine and the law. Here's to the success of your healthcare venture. We look forward to speaking with you soon.